Good afternoon, everyone. My name is Preet Bharara, and I'm the U.S. Attorney for the Southern District of New York. Today we announce criminal charges against J.P. Morgan Chase Bank, N.A., the largest bank in America. The charges are 2 felony counts for violating provisions of the Bank Secrecy Act, or the BSA. The BSA is a law that requires financial institutions, as institutions, to establish and maintain effective anti-money laundering compliance programs and to know their customers. It is not a tip, it is not a suggestion, it is a legal requirement enforceable through criminal sanction. Today's charges have been filed because in this regard, J.P. Morgan as an institution failed and failed miserably. In part because of that failure, for decades, Bernie Madoff was able to launder billions of dollars in Ponzi proceeds, essentially through a single set of accounts at J.P. Morgan. He was able to do that for a lot of reasons, and to be sure, there were failures by lots of people in lots of places outside the bank. But one reason, among others, that Madoff was able to get away with his crime for so long was that J.P. Morgan had an inadequate and ineffective anti-money laundering program. As set forth in the Statement of Facts, for years, the bank repeatedly ignored warning signs, allowed suspicious round-trip transactions through Madoff's account, finally grew concerned enough to file a report in the UK, and ultimately decided to reduce its own exposure to Madoff because of suspicions of fraud. But all the while, J.P. Morgan never filed a single suspicious activity report in the United States and never raised a concern to the bank's anti-money laundering department in the U.S. In other words, the bank connected the dots when it mattered to its own profit, but was not so diligent when it came to its legal obligations. And so all of this is why today we are filing criminal BSA charges against J.P. Morgan, and it is why the bank is admitting responsibility for its conduct and agreeing to forfeit $1.7 billion to help make Bernie Madoff's victims closer to whole. That penalty of $1.7 billion, by the way, is the largest ever forfeiture from a bank, the largest ever penalty imposed by the Department of Justice under the BSA, and it's actually the second largest forfeiture overall, behind only another forfeiture by this office earlier in the Madoff investigation relating to the estate of Jeffrey Pickauer. And by the way, we intend for every penny of that $1.7 billion forfeiture to go to victims of Madoff's massive fraud. And so to date, all told, this office has now collected and will distribute more than $4 billion to those victims on top of what the Madoff trustee has collected. We are also announcing today the resolution of these criminal charges through a deferred prosecution agreement. That agreement requires the bank to, 1, admit and accept responsibility for its conduct through a detailed statement of facts, 2, continue reforms of its compliance and anti-money laundering practices with regular reporting to this office, 3, cooperate for a 2-year period and refrain from committing any crimes, and 4, as I already mentioned, pay a $1.7 billion penalty through a parallel civil forfeiture action, none of which, incidentally, is tax deductible. Now, before I go any further, I want to introduce the partners in this investigation and prosecution. I am joined by our partner in this case and so many important cases, the FBI, led by George Venizelos, the Assistant Director in charge of the New York Field Office. I want to thank George for all the work that he and his team have done in this case. FBI Special Agents Paul Takla, Jared Thompson, Shannon Fish, Paul Roberts, and Patrick Duffy. They have worked incredibly hard for a lot of years to bring us to this point in this case. I'm also joined by some folks from regulators' offices, from the Office of the Comptroller of the Currency, represented here by Deputy Chief Counsel Dan Stepano, and the Treasury Department's Financial Crimes Enforcement Network, represented by Director Jennifer Shasky-Calvary. I also want to, of course, as always, acknowledge and thank the career prosecutors from my own office. They are Arlo Devlin Brown and Matthew Schwartz, the AUSAs handling the prosecutions, and their chief, Anjan Sani. Let me now take a moment to talk about the particulars of today's case. Since 1986, J.P. Morgan and its predecessor institutions was the primary bank through which Madoff ran his Ponzi scheme. He did so through a series of linked accounts that I mentioned that we refer to collectively as the 703 account. Early on, and throughout the banking relationship, J.P. Morgan, because of its vantage point as Madoff's banker, had plenty of reasons to be uniquely suspicious about him. Warning signs abounded. First, as the statement of facts recites, in the mid-1990s, the bank learned that Madoff and a prominent client of J.P. Morgan's private bank were engaged in what looked like round-trip or check-kiting transactions. Large sums of money were being transferred back and forth between accounts for no apparent legitimate business purpose. These transactions were sufficiently suspicious that another bank involved in those transactions filed a suspicious activity report, or a SAR, and closed Madoff's account at the bank. But J.P. Morgan, far from closing Madoff's account, let the transactions continue for close to a decade more, never filing a single SAR or even notifying its own anti-money laundering compliance group. Second, the sheer volume, movement, and use of the funds in Madoff's account were suspicious as well. Between 1986 and 2008, an astounding $150 billion went in and out of that account. And notably, none of it was used for the purchase and sale of securities, even though that was Madoff's stated business. The responsible J.P. Morgan official thought that the account probably had only tens of millions of dollars in it. So as for Know Your Customer, he was only off by several zeros, as the Madoff account, in fact, had billions of dollars. Third, as further detailed in the statement of facts, investment officers and asset managers at J.P. Morgan had serious questions about how Madoff could generate his consistent annual returns of between 20 to 30% year after year after year. A J.P. Morgan banker later concluded that Madoff, quote, might have been smoothing out returns, close quote. In internal bank documents also, one such officer questioned how Madoff was able to generate such consistent quarterly returns despite so much historical volatility in the market. And as early and as far back as 1998, a bank fund manager concluded that Madoff's returns were quote, possibly too good to be true, close quote, and that there were too many red flags. Now, despite all of these alarm bells, J.P. Morgan never closed or even seriously questioned Madoff's Ponzi scheme enabling 703 account. On the other hand, when it came to its own money, J.P. Morgan knew how to connect the dots and take action to protect itself against risk. Let me explain. In 2006, in a different part of the bank, a derivatives trading desk located in the London branch of J.P. Morgan's investment bank decided to offer derivative products linked to Madoff's performance, and as part of a hedging strategy, actually invested its own money in Madoff's feeder funds. In 2007, there were continuing concerns that Madoff was a wholesale and systemic fraud and had a well-known cloud over his head, and that his returns were, open quote, speculated to be a Ponzi scheme, close quote. The concerns heightened in 2008, and J.P. Morgan decided to dramatically reduce the exposure of its own London trading desk to Madoff's funds. And that made perfect business sense. Why? Because in October 2008, internal J.P. Morgan memo described J.P. Morgan's inability to validate Madoff's trading activity or custody of accounts, questioned Madoff's quote-unquote odd choice of a one-man accounting firm. That internal memorandum concluded, quote, there are various elements of this story that could make us nervous, close quote, including the lack of proof that Madoff's, quote, assets actually existed, close quote. Within 2 weeks of that memo, J.P. Morgan filed a report with UK regulators noting that Madoff's returns were probably too good to be true, and that as a result of these suspicions, J.P. Morgan planned to withdraw much of its own money invested in the Madoff feeder funds, and that is exactly what J.P. Morgan did. Between October and December of 2008, as part of a broader reevaluation of the bank's exposure to hedge fund risk, J.P. Morgan successfully pulled out more than $275 million of its money from the Madoff feeder funds before Madoff's fraud was exposed to the whole rest of the world on December 11th, 2008, when he was arrested. Much of what I've discussed is shown on this timeline on the chart to my right. As I said earlier in my remarks, starting back in 1994, there was questionable conduct that the bank had discovered in one part of it relating to round-trip transactions. Then you have the JP fund manager talking about how the returns are possibly too good to be true. Some of the other things I talked about, culminating obviously with the arrest of Bernie Madoff on December 11, 2008. After all these things that had happened that should have caused a thud with respect to so many people who were in a position to monitor and police activity at the bank, but didn't. You had a supervisor of JPMC who had written the October 16th memo that I referenced after the arrest, quote, "Can't say I'm surprised. Can you?" And the analyst confirms, no. Now, today, the largest financial institution in the country stands charged with 2 criminal offenses. Institutions, not just individuals, have an obligation to follow the law and to police themselves. They must exercise due care not only with their own money, but with other people's money also. In this case, as I said, JP Morgan connected the dots when it mattered to its own profit, but was not so diligent otherwise. Fortunately, with today's resolution, the bank has accepted responsibility for its conduct and agreed to continue reforming its anti-money laundering practices. Most importantly, the victims of Bernie Madoff's epic fraud are $1.7 billion closer to being made whole. Now it's my privilege to call to the podium the Assistant Director in charge of the FBI's New York Field Office, George Venizelos.
Thank you, Preet. Good afternoon. Let's have a short statement to read. The FBI and law enforcement in general is only as good as the information we have. We can't be in all places or know all things. We rely on the public to alert police about a bag left on a subway or about a man brandishing a weapon, which is what we call, if you see something, say something. I wish the same could be said about Wall Street. As early as the mid-1990s, questions began to arise about Madoff's business at JP Morgan. Similar questions at a rival institution resulted in the closure of Madoff's accounts for fear of fraud and for transactions for which there was no apparent business purpose. That institution even alerted JP Morgan of their concerns. Instead of taking similar action, JP Morgan kept on with business as usual and benefited from even larger deposits they now held. By 2006, Madoff's business was again being questioned, this time by JP Morgan employees. There was the odd choice of small, unknown accounting firm, or the relying on Madoff's integrity with little to verify its truthfulness. The next year, in an email between JP Morgan executives, one wrote there was a well-known cloud over the head of Madoff and that his returns are speculated to be part of a Ponzi scheme. But it took until Madoff's arrest for JP Morgan to alert authorities to what the world already knew. JP Morgan failed to carry out its legal obligations while Madoff built his massive house of cards. Today, JP Morgan finds itself criminally charged. The result is a deferred prosecution agreement and a record $1.7 billion penalty. Time and time again, FBI agents are told when they make arrests, we knew about that crime for a long time. It's happened with insider trading, and it happened with Madoff. In order to avoid these types of financial disasters in the future, we all need to be invested in making our markets safer and more equitable. Traders, compliance officers, analysts, bankers, and executives are the gatekeepers of the financial industry. We need your help protecting our markets. Often, people in the financial business know about who's cheating. We need to know it too. I'd much rather be here telling you about a bank, hedge fund, or investor who did the right thing. I'd much rather be here telling you about someone who picked up the phone and called the FBI. I'd much rather be telling you a story about prevention instead of heartache for thousands of investors who lost their life savings. Let us work on preventing the next crime instead of preparing to talk about it. I want to thank United States Attorney Preet Bharara, who has been an invaluable partner in bringing these cases. Also want to thank Deputy U.S. Attorney Richard Zabel and Assistant U.S. Attorneys Arlo Devlin Brown and Matthew Schwartz. Also, this investigation wouldn't have been possible without the tireless work of FBI agent Paul Tankler and his supervisor, Kathy Diskin. Thank you.
Thank you, George. Now let me call to the podium the Director of FinCEN, Jennifer Shasky-Cavalry.
Good afternoon. I would first like to thank Preet Bharara and the U.S. Attorney's Office for the Southern District of New York, as well as our colleagues at the Office of the Comptroller of the Currency for their coordination with FinCEN on today's actions. Today, J.P. Morgan has admitted its failure to report the Madoff Ponzi scheme to FinCEN and that its conduct violated the Bank Secrecy Act. A bank files a suspicious activity report, or SAR, with FinCEN when it thinks a transaction may be suspicious. FinCEN, in turn, makes such SARs available to law enforcement. But today's action against J.P. Morgan is not just about a SAR reporting violation. It's about lost opportunities and the catastrophic consequences that can flow. When J.P. Morgan failed to file a SAR with FinCEN, an opportunity to stop this fraud was missed. J.P. Morgan's concerns about potential fraud went unheard, leaving law enforcement and regulators in the dark. A critical piece of the puzzle was left out, and innocent people continued to be victimized. When J.P. Morgan suspected Mr. Madoff's fraud, J.P. Morgan chose to focus its efforts on its own investment exposure. Had J.P. Morgan provided the same level of attention and sophistication to its anti-money laundering responsibilities, it could potentially have saved other fraud victims untold misery and loss. This is an instance where a culture of compliance was lacking at the bank. Of course, fraud, by its very nature, can be hard to detect. But in this case, there were many different points when J.P. Morgan, in fact, was suspicious. For instance, J.P. Morgan speculated internally that Madoff was running a Ponzi scheme. J.P. Morgan filed a SAR in the United Kingdom. J.P. Morgan filed a second SAR in the United Kingdom. J.P. Morgan reduced its own risk exposure to Madoff-related investments. While J.P. Morgan did all of these things, the one thing it did not do was file a SAR with FinCEN at a time when it may have made a meaningful difference. It is my hope that financial institutions learn from what happened in this case, that they pay close attention to their anti-money laundering programs, promote a culture of compliance, and file SARs when suspicions arise. As a result, not only will they protect their institution's bottom line, but they could potentially protect untold numbers of innocent people from falling victim to a similarly devastating fraud. Thank you.
Thank you. Happy to take your questions. Yeah.
You mentioned earlier, you talked about individual accountability. There are a lot of individuals that are quoted here. No individuals at JP Morgan, no individual has lost their job, let alone been charged criminally, and I'm wondering why not and what that makes sense.
Yeah, you know, we often charge individuals, we sometimes charge institutions, and sometimes we do both. The allegations here are with respect to a violation on the part of the institution. And here, given the statute that was applicable here, that's relevant here, the Bank Secrecy Act, is all about directing institutions to make sure that it has policies and procedures in place that can avoid the kind of thing that happened here and that happens with respect to other institutions that have also been pursued criminally this way. This is about an institutional failure, and obviously the statement of facts recites in great detail some of the roles that various individuals played in connection with the overall systemic failure. But the interest of justice here, you got to look at every case individually, and our view is here that at this point, the appropriate charge was against the bank to be held in abeyance if they perform properly over the next 2 years and do all the other things that they're supposed to do. That this is a statute directed towards institutional failure and institutional deterrence, and that's why it was brought in the way it was brought today. Yeah.
There's been so many things at this one bank in the last few months, several criminal actions, a lot of civil problems. Do you think this bank needs to leadership?
I have enough trouble doing my own job. I'm not going to comment on how other people should who should be running other businesses. You should direct that to the bankers or other people. Yeah.
Is there a culture of secrecy there, or why do you think this was allowed to happen for so many years? Can you talk about what you believe the culture to be?
I'm not going to talk about culture with respect to this bank beyond what's in the statement of facts. But as Ms. Shasky-Cavalry pointed out, culture matters. And when you're talking about an institutional failure, which is what we're describing here and what the charges are about and what the statute is about, obviously culture plays a part in that. Yeah.
If you really want to deter this kind of conduct, wouldn't it be a greater deterrent to not defer the prosecution, to convict this bank and to force this bank and its shareholders to bear the consequences of criminal conduct, which is what you usually do to criminals?
You take into account all factors. You take into account the legitimate law enforcement need to have deterrence and to holding people accountable and to bringing money back to victims and to making sure that the punishment is proportional to what the conduct was. And when you're talking about an institution, we also have to take into account, as we're required to, potential collateral consequences. And when you consider all of those things together, we took an action that a lot of people will say was fairly aggressive. It's the largest penalty ever paid with respect to the BSA, and the second largest forfeiture overall, as I described. In connection with the agreement, the bank is required to admit conduct in a detailed statement of facts, as I've described, and that you can read, is required to essentially be under probation for a 2-year period, is required to report back to this office every quarter on its efforts, and is required to pay, a very, very large sum that helps to make the victims whole. So when you consider all the factors and everything that you're supposed to consider in cases like this, including the efforts that the bank has made to reform itself, which it has promised to continue, in our view, what the interest of justice required was this result.
I just asked about the deterrent factor.
Sure,
Whether
you
just considering that, it wouldn't be a greater deterrent to have convicted him. That's the only one I asked about.
Thanks for clarifying your question. In any case, I'll take any case. In any case, you could take the most extreme, for example, if you spit on the sidewalk, I guess the death penalty would deter other people from spitting on the sidewalk. But that's not how we consider individual cases. You look at all the circumstances I've described, including collateral consequences, including the proportionality of the conduct, including the pervasiveness of the conduct, and to see if the action you're going to take, consistent with all of those other principles and all those other important requirements of criminal justice, is also going to have a substantial deterrent effect. And we believe that this will. Yeah.
The bank said today that no, they don't believe anybody at the bank knowingly assisted Madoff in his Ponzi scheme. Is that your belief?
Yeah, like I said before, I'm not going to comment on what individuals' roles were. This is a case, and this is an agreement and the filing of charges that relates to the institutional failure, and I'll leave it at that. Yeah.
Would you speak to the DPA stresses the fact that there was a lack of information sharing between the UK and the US? Would you speak to what the US AML department knew and why they didn't recognize the fraud?
I mean, as I said in my remarks, and is detailed, at much greater length in the statement of facts, the AML department was told very little, depending on which event and which warning sign we're talking about. And to the extent it was told things, there was precious little investigation that was done. I mean, the whole point of this is to make people understand that there was an ability at a sophisticated and albeit large bank, JP Morgan, to have seen what was going on here. And the proof in that is that in one part of the bank, at the London desk, they were able to assess the risk that was going on there and were so troubled about that risk that they took action to protect their own investments. And given that they were able to do that, had they brought that same level of attention elsewhere and there had been fuller and more complete communication between that desk and folks in other parts of the bank, given that the bank was in the position to have unique information about the 703 account, and that's information that was not available to other folks because it was their account in their bank through which most of the Ponzi scheme was able to take place, there might have been a different result. Not necessarily, but there might have been a different result. If somewhere along the way there had been better communication and a better compliance program and a better effort and a better culture, things might have been different. And that's what this case is about. Yeah.
Congratulations to you all. Question, if Jimmy Dimon was in the room right now, what would you say to him? Could you give us an idea of what you might say?
I mean, I'm not going to speak to imaginary people who may or may not be in the room. All I'll say is we speak through our cases, and I think we have spoken at some length when you have a chance on this not toasty day to read the statement of facts, and you'll see that's what that's what we're saying about the case. That there was over time, as encapsulated in the chart here, opportunities for people to have done things differently, and opportunities for people to have cooperated more and spoken more and coordinated more. And all of that, by the way, is borne out by the fact that the gentleman you mentioned has made statements about how he wants to fix the bank, and those are appreciated statements, and has said things about how they are adding people to their compliance program, and as I understand it, have added people to the compliance program, and are committed under the agreement, under penalty of the agreement getting ripped up, continuing to engage in those practices and continuing to do good things, because there was a failure here. I think nobody denies that. Yeah.
In terms of punishing the bank, JP Morgan, why accept payment in a deferred prosecution agreement instead of bringing the bank and its executives to a criminal trial?
I mean, I think I've answered that already. You look at all the circumstances and all the factors, and you want to try to make sure that the interests of justice are being vindicated and all the criminal law enforcement interests are being vindicated. And given everything and all the circumstances and the conduct, we thought this was the best way to proceed. Yeah. Yes, you.
Yeah, sorry. What are the collateral? You said there were collateral consequences. Is what some of the factors that you considered in your decision with this penalty? What caused them?
Yeah, I mean, without reference to this specific case, among the collateral consequences that you consider when you're thinking about charging and indicting and demanding a guilty plea from a business organization, and in particular a financial institution, you have to consider consequences such as employees being laid off, the bank failing. You have to consider consequences such as shareholders losing, innocent shareholders losing substantial value. You have to consider the possibility that regulators will take action against the charter of the financial institution. Without commenting specifically about this case, those are the things you have to take into account.
I have a question for you about the deferred prosecution agreement. It includes conditions that the bank and the individuals of the bank have to report any other further ongoing issues. Is reason, should number one could we expect other individuals might be charged as a result, or is the statute of limitations expired under
I'm not going to comment about what may or may not, I don't like hypotheticals, so I'm not going to comment on what may or may not happen in the future, but with respect to its reporting requirement, yeah, that's an important part of the agreement. It's not, part of the reason that you file charges that you hold in abeyance is so that you achieve something we were talking about earlier, not just general deterrence and making sure that other people don't commit the same acts, but you achieve specific deterrence. And the particular bank in question, JP Morgan in this case, knows that it has to conduct itself well, knows that its culture has to improve, knows that its compliance programs have to get better, knows that communication between different arms and branches of a gigantic bank have to communicate better. And if they don't, then other regulatory actions or other instances of misconduct have to be reported to us, and substantial, more serious action can take place then. People need to be on notice, and individual companies need to be on notice that that's the case, and that's why that's an important feature of this agreement today. Yeah, just one or two more questions. I'm not going to get a calculator out and add them all up. In any negotiated settlement with respect to conduct that occurred over the time period that this occurred, and where you have lots of outflows of money and you have lots of different ways to calculate it, you take into account, as we do with other large settlements that we have announced from this very room, what's the proportionate amount given what all the conduct was. And all things considered, we consider this to be both a serious penalty, so that people understood there's a consequence for a failure of this magnitude, and also making sure that the victims were in a position to get as much money as possible. Yeah.
Yeah, you've been quoted as saying that no one is too big to jail. How is the prominence of the executives involved in this case, or the size of the bank? You mentioned that slightly. How does that come into play in terms of not going farther?
I don't think anybody in this office or anyone standing behind me cares about the prominence of any individuals at the head of a bank or any other company or any agency or any political branch at all. And as I've said before, we are not shy about pursuing organizational indictments. We announced, not many weeks ago here, the indictment and then subsequently the guilty plea of a very significant hedge fund. But just because it's the case that it's appropriate in some circumstances to indict a large institution doesn't mean that every time a large institution presents itself with some level of violation, that every time that institution must be indicted. In the same way that you don't walk away every time, and there are other ways to achieve the interests of justice. So, when it's appropriate to do so, and when in considering all things, including collateral consequences, and what the level of misconduct was, and how pervasive it was, and whether or not there were remedial steps taken, all of those things that I keep talking about, we'll bring that case. Thanks, everybody.